So this is Attorney Brian Pendergraft with the Pendergraft Firm LLC, and today I'm making a video on a question that I was asked on Quora. And the question that I was asked is, can a landlord make changes to a lease after it has been signed? Now, disclaimer, this is general information. This is not legal advice. So for legal advice, you can contact a local real estate attorney that is near you. And if you look to your bottom right of the screen, you can see my answer from Quora. And the shorter answer to the question is no. So once a lease has been signed, both parties are stuck with it. And it can only be changed if the parties agree to it in writing. Now, that is the short answer to the question. Now, I love this question because it represents a fundamental misunderstanding of what is arguably the most fundamental contract law principle. So I'm going to give my long answer to try to expand on this point, because a lease is just a contract after all. So again, this might be the most basic and foundational contract principle that I can think of. So it's important that everyone understands this. So what is a contract? A contract is just an agreement that has been memorialized in writing. So in order for there to be a contract, there has to be what is called a meeting of the minds, which is a fancy way of saying that the parties have to actually agree to the terms. So if I was to change the terms of a contract unilaterally after it's been signed, there wouldn't have been a meeting of the minds. So think about it. I personally enter into contracts to provide legal services. So what if one day I decided that I wanted the PlayStation 5 one day? So I decided I'm just going to, after clients retain me, I'm just going to write on their agreement that, you know what, that has already been signed and executed. I'm just going to write on that agreement, you have to buy me a PlayStation 5. So would they actually be bound to that agreement? Of course they wouldn't. So there was no actual meeting of the minds. And that principle applies to leases, retainer agreements, or any other contracts that you can think of. For a person to unilaterally change contract terms after they've been signed, that's fraud. So in order to make changes to a contract, it has to be agreed upon by both of the parties. Preferably in writing, particularly for real estate contracts. Remember, leases are real estate contracts because most jurisdictions have a real estate statute of frauds that require agreements regarding land to be in writing. So I think landlords in particular need to be aware of this, because a lot of times they may work out a payment plan or they may work out a lease modification with tenants, but it's not in writing. So yeah, that's about all I have to say. And if you have any questions or you would like featured in my hashtag Ask a Real Estate Attorney series, just let me know in the comments. Also, if you can like and subscribe to this video, or like and subscribe to my channel, I would appreciate that. And thanks for watching.